Hey friends, how is everybody? Welcome to True Crime Wednesday. Boy, do we have a lot to talk about tonight. I'm Lori Hellis. I'm your host. I am a retired criminal defense attorney turned author, and those are my books. We have a lot to talk about. Holy cow. We have Kohberger, we have P. Diddy, we have a lot of news on small bits of news on other cases. We have Lori Vallow's interview with Nate Eden to talk about. So hold on, because we have a bunch of things. Polio, I just want to say thank you so much for your super chat. That's very kind of you. We don't solicit them, but we do appreciate them. So thanks so much. So welcome, everybody. I wanted to start out, first of all, please subscribe, hit the like button, do all the YouTube things, because it does help us out. I want to talk tonight about a couple of sort of housekeeping things before we dive into a lot of the meat of our evening. So first of all, I do want to talk about the fact that y'all know that I've been working on a new project, not quite willing to unveil that, and I know I keep teasing you with it, but I'm a little gun shy about putting it out there until I have it locked down. Mostly because I really don't want somebody else to jump in. So I'm just going to hold off on explaining it. But because of that, I definitely have kind of had to reorganize my work days a little bit. So while I'm working on that, and because it's summer and we're all busy during the summer, for those of you who don't know, I live in Central Oregon, and Bend, Oregon is the kind of place where people come to recreate, especially all year round. We have a ski resort. All year round there's something going on. But summers in the high desert of Central Oregon are heartbreakingly wonderful and beautiful. Nobody who has any sense ever leaves Central Oregon during the summer. We all bail out in the wintertime to go someplace where there's sun. But it is absolutely wonderful here. So I'm super excited. 4th of July is coming up, the long weekend. My daughter is coming by to pick me up to go kayaking tomorrow, and we're getting up in the high lakes for the first time, so I'm excited about that. But what that means is that we're going to be cutting back on our True Crime Wednesday shows for the summer. So we're going to be doing them twice a month rather than every week. So we'll be having a show on the 16th of July, which is 2 weeks from now, and then on the 6th and the 20th of August. And then we'll get back to a regular schedule in September. And I anticipate that you're going to see some changes. We're going to probably have a new email address and maybe a little bit more of a newer look, and some announcements to make about the new project and some changes. Sharon Hutchinson, if you are going to be in Sun River in August, please DM me and let's have coffee, because I am going to be here all summer. And that goes for anybody else who's going to be in Central Oregon this summer. So please reach out to me, DM me if you are going to be in the area, and let me know, because I would love to get together for coffee with anybody who's vacationing here. The other things I wanted to talk about before we dive into the specific cases is I have recently read a couple of books. Some of it's research, but they're really good books. So if you are into true crime books, this one is really good. It's called Junk Science and the American Criminal Justice System, and it's by Chris Fabricant. Chris Fabricant is a member of the Innocence Project, we have all talked about junk science at length. In my newsletter, archive, there are a couple of newsletters that really dive deep into junk science. In 2009, there was a report that came out from the National Academy of Science. I would have to look it up, but since I have it up on my computer, um, it is from the uh, of course, I have to go all the way back up to the title page. Um, it is from the National Academies, National Research Council, sorry, of the National Academies. It came out in 2009, and it was it was a report based on scientific analysis of a lot of different kinds of um, scientific forensic science. And it was pretty scathing of a lot of them: bite marks, ballistics, hair comparisons, to some extent fingerprint comparisons. So it's a although it came out in 2009, so almost 20 years ago, it was a very important study because it really pointed up the deficiencies in any sort of forensic science that relied on subjective pattern matching, where somebody was saying, I looked at this and it matches. Um, so it's a really good book. Um, I think that it is easy to understand even if you're not a lawyer. And I think it has some really important stuff in it. One thing I wanted to point out to everybody, which I'll get to a little bit later, has to do with some of the people who have really hung their careers on junk science. The other one is this one, and it is really good. This is Murderland, Carolyn Fraser, Crime and Bloodlust in the Time of Serial Killers. You can see our friend Ted Bundy is on the cover. This author is really amazing, and it is fascinating because she ties the widespread throughout the Pacific Northwest in particular, use of smelters to extract both precious metals as well as lead and arsenic and a lot of other elements out of ore. And the fact that those smelters were pumping lead and arsenic and a lot of different poisons into the air for many, many years, and people were living on places that were had been slag piles, or living around water that had been used to dispose of the elements. And she posits that that had an impact, and that was a reason why we saw a marked uptick in the Pacific Northwest, in particular, of serial killers and other people who had similar sorts of behavioral issues. So she talks about Ted Bundy, about the Green River Killer, Ridgway. She talks about Israel Keys. She talks about, I mean, it is, and it is a fascinating book. It's also beautifully written, so highly recommend if you're interested in that sort of stuff. Um, she did a really good job. She definitely does spend a fair amount of time on Ted Bundy, because he really was sort of the beginning of what we look at as serial killers. And she definitely has a different take on some of the stuff that happened with him. So highly recommended. Um, So, that said, let us talk about Brian Kohberger. So I am sure that you all were totally shocked, as I was, when we heard that Brian Kohberger was going to take a plea. Now, I will say that I have represented um, violent criminals. I have represented everything but capital cases. Always, um, I avoided taking capital cases, mostly because I had a child in a school system in a fairly small town, and I really didn't want that level of visibility for her. Um, I thought it was bad enough that there were times that I represented people in high visibility cases. I tried really hard to avoid being mentioned in the paper. I had a deal with the woman who was also a mom, who covered the courthouse, that she would sort of keep my name out unless she let me know. Mostly because I really didn't want my daughter to go to school and have the kids in her class say, "Hey, your mom's representing the baby raper or the bad guy," or So I I avoided capital cases for that reason. Would I do them now? Sure, if I was still practicing. But and I am still a member of the bar for the purpose of doing pro bono work, and I may do some work with the Innocence Project, the local Innocence Project here. So um, I uh, I didn't take those kind of cases, but I did take complex and violent criminals. And I understand that Ann Taylor and her team were doing their best to save their client's life. That's their job. And I have said all along that I was somewhat surprised that Ann Taylor was as adamant as she was in the beginning about Brian Kohberger's innocence, because you don't see defense attorneys often outright saying, "My client is factually innocent." Um, you see them saying, "I'm going to do everything I can to protect my client's rights." And you see them saying, "I don't believe the state has met their burden." But you don't often see a defense attorney who just outright says, "My client is factually innocent." I think that was something that happened in the Karen Reed trial, and there was a lot of evidence to support that, but you don't see it often. I think that there were a few things that were going on. Um, I think that as the case went on, and as the defense team went through the discovery, they raised concerns with their client about the evidence that was stacking up against him. He ordered a K-bar knife months before and a sheath and a sharpener months before the crimes. His car is seen around the property many times, 20 plus times. Um, by the way, today was an eventful day. So I'm having a glass of rosé. I hope you guys are all um, consuming your favorite beverage. So the uh, the next thing is that I think that as they went through all of the evidence, their responsibility is to lay out all of the facts for their client. So Ann Taylor clearly is sitting down and saying, "Here's everything that we have to contend with as a defense team. We have this, we have this, the state has this." I also think that it is possible that as they were doing their mitigation work, they were finding information that was going to make Brian Kohberger look very unlikable. So not only were they concerned about the guilt and innocence phase, which they clearly were worried about, but they were also, I think, concerned about the penalty phase. If he were convicted and it was looking more and more like that was going to happen, what would the penalty phase look like? And it appeared that, I suspect, let's put it that way, I suspect that all of the work that they were doing for mitigation was coming up empty. And I think you heard that at, I think you heard that as Ann Taylor was trying to get a continuance so they could do more mitigation work. I think at the heart of that was that they were having trouble coming up with mitigation information that would lead a jury to say, we believe you ought to spare his life. That's rough. And I think that reading in between the lines, that's what was going on. So I think that's a combination. So Ann Taylor had to go to her client and she had to say, look, here's all the evidence that they have against you. We think that there is enough that if the jury believes all this, you could get convicted. Here's the dilemma. We're not turning up the kind of information that would convince a jury not to impose the death penalty. And so I think as time goes on, that gets more complicated for the defense team. So Ann Taylor has also exhausted a lot of her other attempts to get rid of the death penalty. She's filed all of the typical challenges to the death penalty. She's filed challenges to discovery, which is what got Lori Vallow out of the death penalty. And that was also in Idaho. So she's tried that avenue, and that hasn't worked. And so she really is sort of stuck with saying to the guy, look, regardless of whether you are actually guilty or not, here's all the evidence that is stacking up against you. And oh, by the way, we're not turning up a lot of favorable mitigation information. So that, I think, also, the next problem is that they have, the judge, Judge Hippler was a very straightforward judge, and he was a very by-the-book judge. And he understood the absolute immensity of what a trial was going to look like. And he was saying, this has to go forward. You cannot, I mean, we learned today that the judge had ordered that there be no other trials in the courthouse the week that they summoned the jury, because they had summoned 10,000 people, knowing that, of course, a large percentage of them are going to fill out the questionnaire and say, yeah, I know all about the case and I can't serve. But even at that, there was a huge number of potential jurors that were going to be coming to the courthouse, and the courthouse was literally shut down for the first week of jury selection. So you're right. Can you imagine? So he understood the immensity of what was going to happen. Now, I got to know the trial court administrator at Ada County when I was there covering Vallow and Daybell. And she did a masterful job during Vallow and Daybell. So she's got some experience with how to handle these very high profile cases. But, you know, uh, uh, I mean, even when Chad Daybell's uh, trial was being live streamed, there were days that the line was out and around the corner, and there weren't even enough seats in the overflow seating to get people into the courthouse. So I know that that was going to be a problem in during this trial. Just the media alone wanting to be there in person. And having been in that courtroom for Vallow and Daybell, and it is the same courtroom. It's the biggest courtroom in the Ada County Courthouse. Knowing that space, there's about 70 seats in the courtroom. Um, and then there's another maybe 100, in the overflow room, which is the county commissioner's meeting room. So, uh, I mean, that's barely going to scratch the surface of the people, because the first probably 20 to 30 people are going to be family and victims advocates and investigators on both sides and the police. And so, I mean, you're going to be lucky if there's another 40 seats for the public. And as was the case with Vallow Daybell, there were no special passes for media. It was first come, first served. And so a lot of the big organizations had line sitters that were there to stand in line to get in. And I know that that was the case today. I mean, Anjanette Levy was saying that she had a producer standing in line for her from early morning to get into this. So I know that it was going to be a really big operation, which plays into how quickly this plea got taken and scheduled. So, all of that being said, when Ann Taylor says to her client, I have real concerns. We can't get a continuance to do more mitigation. What we have right now is not good. I think they have enough to convict you in the guilt and innocence phase. I don't think I have anything that is going to mitigate the death penalty, and I desperately want to save your life. So, what do we do? Now, I don't know whether Brian Kohberger had ever told the truth about whether or not he was involved. Oftentimes, lawyers will tell their clients, I don't want to know, because I don't want to be put in the position of having to put you or somebody else on the. Thank you so much, Tina. That's so sweet of you. Anytime. And I love being here with you all. So I think she was in the position, a lot of lawyers will say, I don't want to run the risk of having to put anybody on who might lie, because I would have to tell the court, because I have a duty of truth to the court. So I can't at any point, if I know there's somebody lying, I can't do that. And particularly if your own client is going to take the stand and they're going to tell a different story, and you know it's not true, you can't be put in that position. So I know it seems kind of weird that defense attorneys will often say, don't tell me, la 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 la, don't tell me. So I don't know if up until the time that Ann Taylor had this, what I always called the come to Jesus conversation with her client, that he was prepared to actually have that kind of a frank conversation with her. But the judge was very clear that he did not want Kohberger to plead guilty unless he was actually guilty and had committed the crimes. Now, you note that Brian Kohberger did not take an Alford plea. I don't know whether that was ever on the table, probably not from the prosecutor, although maybe because the prosecutor really w would have loved to say that um, that they were avoiding a trial. I think the prosecutor at some point would have said, you know, taking an Alford plea might be worth it in order to avoid having this huge trial, bringing in 10,000 jurors, having this huge production on behalf of the court. You know, to be truthful, prosecutors, it doesn't change the cost of prosecuting a case. You know, prosecuting a murder case like this is going to cost, and it's going to cost the state to bring in experts and do all of those things. But that work's already been done, so it really wasn't. It really wasn't a factor for them to say, we're going to save a lot of money by not having to have this trial. The prosecutors already done their work and spent their money. But the issue was whether or not this was going to be a huge imposition on the court trying to get this case tried. So I think Ann Taylor sat down with her client, absolutely, because she's doing her job, sat down with him and said, here's the reality of what we are facing. You need to tell me where we go from here. And I think she said to him, I think there is still an opportunity for a plea, and I desperately want to save your life. Because that's what defense attorneys feel and do. Um, we generally don't like the death penalty. We generally don't believe that it is administered fairly. In many cases, it is inordinately imposed on people of color and people of and indigent people. And so most of us would say, given the opportunity, my priority is to save your life. This is funny. Behind me, this light keeps coming on and off behind me. I have an automatic on and off in the hallway coming upstairs, and I apparently have a cat in here with me because he keeps triggering the sensor on the stairs. Um, so anyway, you'll see it go on and off. So I think that's what she did. I think she said, my advice is that I want to save your life. Um, I realize that that means you're going to spend the rest of your life in prison, but you're gonna have a life. Um, so I think she did, and I think that they helped him come to that decision. Now, I saw on first of all, I do not play in the sewer of X or Twitter. Um, I'm just over it. It's too awful and too toxic there. You can find me on Blue Sky and Instagram and Facebook, but not on Twitter. Um, so I have heard that there are some people on Twitter who are contending that he was coerced into a plea. I do not believe this. This is a guy who was pursuing a PhD in criminal justice. He's not a dummy and he fully understands his rights. Yes, he is autistic. Yes, he is quirky, but he is not unintelligent and he is not uninformed. And I do not believe in any way, shape, or form that he could be coerced into taking a plea. I just don't believe that. Now, we talked a little bit about Alford pleas. Alford pleas, it comes from a case out of the U.S. Supreme Court that's where a guy was forced, he was offered a plea to avoid the death penalty. And he said, I'm factually innocent, but I want to take advantage of this and save my life so that I might have the opportunity to fight to be exonerated. And So he said, I won't plead guilty, but I will agree that the state has enough evidence to convict me. It went all the way up on appeal, and the Supreme Court said yes, that was a proper plea. So it's called an Alford plea, and it essentially it's some states call it a no contest plea. Most states have some form of an Alford plea, and all it means is that the defendant stands up and says, I don't want to plead guilty, but I acknowledge that the state has enough evidence to prove me guilty. It's still a conviction. It still goes down as a guilty plea, for record's sake, and but it does preserve some rights, particularly some potential appellate rights. So um, that is, I think, what happened. And Taylor sat down with him and said, here's where the rubber meets the road. Here's the bottom line for you. And I will do whatever you want me to do, but I want to save your life. And he agreed. So I think the difficult part of it was, and here's let's talk a little bit about how this happens when you have a family, you have victims. So the prosecutor, and understand that the prosecutor is the person who has discretion. You hear all these things about this person didn't want to press charges. Well, they don't get to decide. The prosecutor decides. And it is not a matter of you saying, I want to press charges or I don't. The prosecutor decides whether or not there's facts and evidence enough to charge someone. And you can come in as the victim of a crime and say, I don't want to press charges. And the prosecutor's going to say, I don't care, because it's not your choice, not your decision. And that's the case. So when the prosecutor, when Ann Taylor, and all the indications are that the defense went and approached the prosecution late last week and said, do you have an offer? Will you make us an offer that includes him avoiding the death penalty? And the state came back and said, yes, but he has to agree to the maximum sentences on all 5 charges. There's 1 charge of burglary and 4 of counts of murder, one for each victim. And he has to agree that those are going to be served consecutively, one after another. So that's huge. And Ann Taylor said, okay, if you take the death penalty off. Ann Taylor didn't say that, Brian Kohberger did, because ultimately the decision is Brian Kohberger's. Ann Taylor can advise him, but there are many decisions that counsel cannot make for you, and that is one of them. So he decided that he would take the plea. We're going to talk a little bit more about what the prosecution can force him to do and what they cannot. So a lot of people have said, we really risk the prosecution had demanded that he make an allocution. They can't do that. It's not constitutional. He has a Fifth Amendment right, even though he is giving up his right to self-incrimination when he pleads guilty. He does have some rights not to be forced to do a full accounting of his step-by-step of the crime. So after Ann Taylor approached the prosecutor came back and said, we'll agree. And the court was notified on Friday afternoon. Now, here's Judge Hippler saying, holy cow, I've got 10,000 subpoenas that have gone out to potential jurors. I've got jury summons, 10,000 of them out there. So if we're going to do this, I need to get this done, and I cannot call off all of those subpoenas until he enters his guilty plea. I cannot comfortably and properly call them off. So he's got 10,000 people who are potentially coming into the courthouse the week after 4th of July. He can't call them off until he's sure that that Kohberger is actually going to enter a plea. And up until he got to court today and stood up and said, "Yes, I understand and I'm guilty," the judge couldn't call off all of those subpoenas, all those jury summons. So that was the reason why the judge said, "We got to get in here Wednesday morning and we need to put this on the record." Because once that was done, it was sealed, it couldn't be taken back, and Kohberger couldn't change his mind. So then the judge could call off the jury summons. So that was the reason for the rush. But what happened was the prosecutor said they had a meeting, I think by Zoom, with as much of the family as they could, but that didn't include all the family, and not all the family was on board. All the families, the victims' families, not all of them were on board, and many of them, some of them had mixed feelings about it. So, I mean, these are 4 separate families of victims, and not even within each of those families is there unanimity on how they feel about it. I am not ever going to judge how people feel about the loss of a loved one, and I certainly am not going to judge someone for a parent for losing a child. We know that these 4 young people were so vital and so promising in their lives. I mean, if you know anything about them, yeah, they were young and they partied, but they were also excellent students. They were also uh, Dean's List. They were also had much beloved in their communities. I mean, these were young people with all of the promise and their lives ahead of them, and with all of the possibilities that they could have done something amazing for the world. And their lives were cut short for no reason, by a complete stranger. And I cannot even begin to imagine the pain that these families have been through. So I am not going criticizing how any of them feel. They feel how they feel. Okay. I'm not even going to criticize the families for being very vocal about feeling the way they feel. Now, we know that Kaylee Gonsalves's father, Steve, believes a lot of things. He believes that Kaylee was the target, that he was Kohberger's primary target, and that the rest of the kids that were in the house were simply collateral damage. He believes that nothing short of a trial and the death penalty would bring him any sort of satisfaction. And I am the last person in the world to say he's wrong. He is feeling what he feels, and I cannot even begin to imagine that. I will say years ago, now my daughter's 30. Years ago, I have a family member who lost a 3-year-old boy to a drowning. And I thought at the time that I could sympathize with them and I understood what they were going through. A couple of years later, I had my daughter, and they were visiting, And I looked at her and I said, "I honestly do not know how you ever got out of a fetal position. I thought I was being sympathetic, but I had no idea. And I can't imagine what you went through. And I don't know how you ever recover." So I am not ever going to call out these families and say that they were wrong. But what I am going to say is I think that Steve Gonsalves went too far. He put out on social media that people should be um, reaching out to the judge and demanding that the judge not accept the plea, that the judge, that the judge insist on going forward with trial. And I understand that he is a grieving parent and he is not a lawyer, and he does not understand that the judge simply doesn't have that authority. Um, Judges are granted authority by their state statute, and that state statute very clearly lines out their powers and what they can and cannot do. And a judge cannot refuse to take a plea in a case where the person is doing it knowingly, intelligently, and voluntarily. And if the prosecutor and the defense have agreed, and the judge absolutely cannot refuse to take that plea. And so it put the judge in a difficult position. They were inundated with communications, calls, and emails. And the judge was understandably not happy about it. And so he began the sentencing or the plea hearing by explaining why that was inappropriate and why he didn't have the power to do the things that the people were demanding that he did. So I thought he did a very good job. He is a very straight down the middle, but very transparent judge. And I thought that he did a very good job of explaining the reasons why he was not acknowledging any of those communications and that he was not going to go there. And that he gave them a stern warning. This is not appropriate conduct. I thought it was interesting. I watched Anjanette Levy from Law and Crime has a YouTube channel now, and I watched her just before I came on, and she was saying that Steve Gonsalves refused to enter the courtroom and was not there. The rest of the family went in, but he refused to enter the courtroom because he refused to be in the same room with the prosecutor. And Because he's very angry with the prosecutor for having cut the deal. I think that there is a much bigger picture to be considered. So my understanding is that Xana Kernodle's family, at least some of them, were very unhappy with the deal. On the flip side, Madison Mogen's parents, both her father and her mother and stepfather, um, supported the plea 100%, as did Ethan Chapin's family. Ethan Chapin's family have from the very beginning been so graceful in all of this, and so loving and yeah, loving and concerned about the other families, concerned. Ethan was one of a set of triplets. He was a triplet. I think they've been very focused on their own family and helping their own family chart this really perilous journey. Um, so I think that initially the judge denied bringing in any potential third-party culprits. If you remember from the hearing a week or two ago, part of that hearing was under seal, the part of that hearing that was under seal was to talk about the third-party culprits. The order that the judge issued having to do with that essentially said, these people have all been cleared. They've all been excluded for one reason or another, and there's no reason to believe that there's any credible evidence to bring in a third party. He denied the continuance, and in the order that he issued, which was lengthy and quite well reasoned on the denial of the continuance, he was pretty scathing against the defense. He was pretty, eh, and I understand it. Here's this judge, he's trying to get this trial done. And this attorney keeps putting every barrier up she can. That's her job. She's trying everything she can to try and find enough information to save her client's life. That's her job. And the judge, I mean, you really do get to the point where the judge is going to have to call the balls and strikes, and the judge is going to have to say, no more continuances. There's no basis for this. He was very critical of the defense, justifiably so. And I think Ann Taylor would have said, you're right, Judge. Justifiably so. You are completely justified in being critical, but I'm doing my job. And so I thought the plea hearing was very thorough, and the judge really did elicit from Brian Kohberger, and I'm just going to play a little clip of this for anybody who hasn't seen it yet. I am going to share my screen. Just to sort of give you a flavor of how the judge was.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonsalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
So you see, the judge was very thorough and took this a step beyond what most pleas, where most pleas go. Oftentimes what happens is you see a judge say, how do you plead? Now, further on in this video, he does say, as to count one, how do you plead? He says guilty. But the judge took this extra step of laying this factual basis by saying, did you do this? And he had to respond and said yes 5 times, including, did you enter the home with the intent to commit murder? So I I think this judge was being very thorough, and I think that Brian Kohberger had been prepared by Ann Taylor to do what he needed to do. Now, did it surprise me that he was very stoic and pretty stone-faced about it? No, not at all. This, to me, seemed like a very typical entry of plea. This is not, it's not LA law or Boston, whatever. This is a very typical plea. This is, people are not required to stand up and give an allocution. Now, could he at his sentencing? Yes, he could. His sentencing has been set for the 25th, or no, 22nd, I believe. So the judge discussed with them the week that they have set aside when the courthouse is going to be closed is the week that they're going to do the sentencing. And I think, now that I think about it, it is set for the 23rd of July and expected to go all day. That will be the time when the families will be able to give their impact statements, and when, if he's going to give an allocution, he will do that. So today was not the day for that. Now, I want to remind you that in Idaho, the statute says that while it is possible, it is victims of crime have a right to come in and address the court with a victim impact statement. They cannot address Brian Kohberger. We ran into this in the Vallow case, where Lori Vallow's Chad Daybell's sentencing was done the same day. It was very different. But Lori Vallow's sentencing was set out, and the judge then heard from a lot of the family. But the judge specifically directed the family that they could not talk about Lori. They could only talk about how the deaths of their family member impacted them in their lives. They could not talk about her and how she impacted them. At one point, Tammy Daybell's sister was talking, and the judge interrupted her and cautioned her that some of her remarks weren't allowed. So I don't think this judge is going to allow fiery family impact statements. I think Steve Gonsalves is going to want to do that, and I think that may cause some friction in the courtroom if he tries that. And it may be that the judge has to intervene in a very stern and decisive way, including potentially saying you need to leave the courtroom, because I think it is very clear from Idaho statutes that you are not allowed to come in and direct your comments at the defendant or the defendant's behavior or conduct. You're only allowed to come in and express to the judge who's going to do the sentencing how the loss has impacted you. So now, that being said, both sides waived a pre-sentence investigation. Now, a pre-sentence investigation was done in Lori Vallow's case. She refused to cooperate with it, so it wasn't all that helpful. But what usually happens is a separate office at parole and probation is tasked with doing pre-sentence investigations. So the pre-sentence investigation includes the person's prior criminal history, any details of that, if the person has a prior criminal history that might impact sentencing, as well as education and mental health. And it's usually fairly in-depth, not anywhere near as in-depth as a mitigation phase would be in a death penalty case, but it is fairly in-depth. They will talk to family members, they will talk to victims' families, they will talk to Kohberger's family members, they'll look into his education background, a lot of other things. But in this case, it probably made no sense to have a pre-sentence investigation, because that's done to inform the judge of what, give the judge enough information to decide what the sentence is going to be. In this case, Kohberger has stipulated to the sentences, to the maximum sentence on all counts. So let's talk about what that means. So in Idaho, first-degree murder, there is, we've talked about this before in the Vallow case. The only way that you get to life without parole is if the death penalty, if you're found guilty and the death penalty is imposed, and then mitigation says it shouldn't be. Now, in Lori Vallow's case, because the judge took the death penalty off the table, he ruled that the potential sentence was still life without parole, because he took the death penalty off the counter. So in Vallow's case, that sentence of life without parole was available. In this case, because he cut a deal and that took him out of the death penalty, the maximum is life in prison, with a 10-year minimum before parole might be possible. Now, don't panic, because he also agreed that all of these sentences would run consecutively, which means one after another. So he serves 10 years for the burglary. That was a maximum sentence on the burglary, was 10 years. So he gets 10 years on the burglary. So then the next sentence is a life with possibility of parole after 10 years. But after that 10 years, he then goes on to serve the next 10 years and the next 10 years. So all total, he has 50 years before he would even be eligible for parole. So in essence, it is a life sentence. Even if after 50 years he asks for parole, the parole board's not going to parole him. So I don't think there is any risk at all that he ever gets out of parole. The judge also imposed restitution and some fines and fees. In essence, those are never going to be collected. There was some information. There were some. The judge, I'm sorry, I was trying to look at a comment while I was trying to catch my train of thought, and it was running off the tracks. Essentially, he has no money. Somebody asked whether or not his parents could be held liable. No, they can't. He was an adult, and his parents have no liability for the actions of an adult child. So, no. But I think what can happen is if he has a job, we saw this in, gosh, I can't remember which case it was now, but we saw it where if a person has a job, the money that they make in the prison that would usually go towards their commissary, goes towards their restitution obligations. If people put money on their books, a certain percentage of that goes towards their restitution obligations. So, but essentially, I mean, it'll be pennies. And certainly nothing is ever going to make these families whole. So that restitution really wasn't the issue. So, so I understand that no one is ever going to be completely satisfied with this outcome. There are way too many people who want to know why. Now, will Brian Kohberger at some point give us that information? I don't know. I did see a comment here, and I'm going to put it up because we're talking about this. Catherine Ramsland is an expert on psychologist on serial killers, and actually wrote a book about BTK. And but she didn't write it with him because he could not profit. So that was not a co-authored book, but she wrote a book about him. She is on tonight with Joel Waldman at Surviving the Survivor. She and her name just went out too. Psychologist Ann Burgess, who is the other one, and I'm anxious to see what they have to say. I know that Dr. Ramsland, because she taught Brian Kohberger. I know that she has avoided talking about it, and I think last night was the first time she's talked at all about it. I hadn't heard that she was not going to be on STS, but we'll see. I think she's in a tough place with all of that. So I will just take that down, and we will continue to chat because we have several other cases to talk about. I mean, Kohberger obviously was the big deal for the day, but I don't want to lose sight of the fact that there are several other cases that I would like to talk about. So hold your questions until the end. I like to sort of give my thoughts, and then we set aside time at the end to answer questions. And I love answering questions. So if you have them, hang on to them. It's easier for Jen, our moderator, to spot them if you hold off on them till the end. But there are some other cases that I want to talk about tonight. Here, I thought we would be talking wall to wall about Nate Eaton's interview with Lori Vallow until Kohberger happens. So, and we're going to get to that, but I do have a couple of other ones I want to talk about. I want to talk about YNW Melly. This is Jamon Demons is his real name, and he is a rapper from Florida. And he has been in custody since 2019. So let that sink in. That is 5 years. He had a trial that ended in a hung jury in 2023, and he is still awaiting a second trial. And it is a mess. There is so much stuff going on in this case. It is yet another one of those cases that makes you wonder what in the heck is going on. So first of all, he has been trying to get back to trial forever. And there has been all kinds of stuff. There was a prosecutor who was tossed for prosecutorial misconduct in this case. Then the prosecution started going after one of the defense attorneys, claiming that she had been tampering with witnesses. But all they did was announce that she was under investigation as a way to try and get her off the case. So she's still on the case. Then the prosecution wanted to show a bunch of videos, which were essentially Melly's music videos. And, music videos, I mean, he's a rapper, so it's all about the thug life. That doesn't necessarily mean they could be very artistic and could be a lot of creative license. Doesn't mean anything about what he actually believes. But the prosecution wanted to show them. The defense objected, and the judge ruled that they did not come in. And now the prosecution has asked the Supreme Court to weigh in an interlocutory appeal. Interlocutory appeal is an appeal of a pretrial ruling. So now it's on appeal up to the court. So now the prosecution saying, well, we can't go forward with the trial that's scheduled in September finally. By that time, he will have been held pre-trial over 5 years. We can't go forward with the trial because that's still pending. Now, there is a hearing on the 9th of July to discuss whether or not the trial is going to go forward. So we'll know a little bit more about that. But I'm telling you what, this guy has been held an inordinate amount of time. And I think his speedy trial rights have been violated right, left, and center. And it would not surprise me if eventually his conviction is overturned and dismissed with prejudice because of this lengthy delay in getting to trial. I mean, it is ridiculous that it is 2 years past the mistrial, the hung jury, and we still have not gotten to trial. People ought to be outraged about that. So I think they're just sort of biding their time because they think the longer that it goes on, the more likely it is that he's going to walk. So, and speaking of walking, let's talk about P. Diddy. So P. Diddy was in federal court facing federal charges. So there was no publicity, nothing streamed. And yesterday it went to the jury, and the jury was having some difficulty with a couple of the charges. They initially sent a note out saying that they were deadlocked on the RICO charges. Surprise, surprise. We talked about the fact that RICO cases are very complicated because you have to get to those underlying predicate crimes. And the reason they bring RICO is usually because the underlying predicate crimes, the statute of limitation has passed, which is the case in Diddy's case. A lot of people were complaining, why didn't they bring state domestic violence charges or state assault charges for his abuse of Cassie Ventura that was caught on video? And the problem is that that was an issue at the state level, and it was the state prosecutors who decided not to bring those charges. As a result, Cassie Ventura settled for $20 million with P. Diddy and $10 million with the hotel, who didn't report to the police when they knew that the incident had happened. So they went through all of the evidence. The jury finally came back and said, we cannot reach a verdict. Oh, no, actually, they started out by saying they couldn't reach a verdict. They went back, came back, and found him not guilty on the RICO charges, found him guilty on 2 felony counts of transportation for the purpose of prostitution. So violation of the Mann Act. Transporting people across state lines for the purpose of prostitution. So his lawyers then immediately asked the court for bail because he was only found guilty on the 2 charges. The judge denied it pretty summarily, saying, I saw all the evidence, and even though the jury found him not guilty on those charges, I can consider that in making a bail determination. The judge can also consider that in making a sentencing recommendation. He was referred for a pre-sentencing investigation, and sentencing was set for October 3rd, but both sides asked if they could expedite the pre-sentence investigation, if they could also expedite the sentencing. So his sentencing could take place earlier than that. So that's where we stand. He is still in custody, will remain in custody until he is sentenced. No idea what the sentence will be, but there seems to be some division on what the sentencing recommendation should be, and both sides will be submitting memos to the court with their interpretation of what the sentencing guidelines call for. So the next thing, see, I had this all queued up to talk at length about Nate Eaton's interview with Lori Vallow, but we still have a lot more to talk about. So it was really fascinating. I will say I thought Nate did a good job. Those of you who know me know that I might not be a big fan of Nate for some personal reasons, but I thought he did a good job. You know, I'm the first one to give credit where credit is due, even if I'm personally not a fan of that person. So credit goes to Nate, who did a really good job. He made an agreement with Lori Vallow that he would not edit this. She was very upset by the Dateline Keith Morrison edit because Keith Morrison basically edited most of what she wanted to say out because she was so unintelligible. But Nate Eden agreed that he was going to present it as raw at the 30 minutes of their interview. So he did. Which I don't think did Lori Vallow any favors because she got to ramble around a little bit. But he really did do a good job of bringing her back to his questions. And he asked some very pointed questions for which she had no answers, as usual. She went off on her Jesus is going to save us all, and Chad and I are going to be exonerated, and the Nephites had 7 life sentences and 7 death penalties, and they still escaped. So I thought it was interesting. I will say that I watched Colby Ryan's reaction to it, and I really appreciated his reaction to it. I think we have seen Colby, who is Lori's eldest son, mature tremendously over the last 5 years. And I really think that he deserves a lot of credit. I also will say that they just made an announcement that he and Brandon Boudreau are going to form a media company, which I think is huge and going to be wonderful for them. Now, remember, Brandon Boudreau got a big payday for libel and slander from the attorneys that were representing Melanie Boudreau and Zulema in California. And they also represented Melanie in her divorce from Brandon and did some pretty heinous slander and libel. So he has a little money to invest in a project like that, and I'm excited for both of them. I think it was really a great move. So if you get a chance, do take a look at Colby's reaction video to the interview. I thought it was very enlightening. His YouTube channel is called Scar Wars, SCAR, Scar Wars. So that being said, she is scheduled for her Arizona sentencing on the 29th of July, and she has sent out a lot of mixed messages. On one hand, she wants to get the heck out of the Maricopa County Jail, which is not the Ritz by any means, and back to Idaho. I mean, I've told you over and over again, being in state prison is a much better gig than being in county jail. And so she characterizes the Maricopa County Jail as the worst jail in the country. I don't think it's anywhere near that. She hadn't been in some of those jails down south. I strongly suspect that some of the jails in Louisiana, Mississippi, that area might be pretty uncomfortable themselves. So I don't think by any means Maricopa County Jail is the worst jail. It's big. It's a big jail and has a large population. And I think that jails that have a large population, I mean, she was spoiled being in Rexburg. So, I mean, she was basically in her own pod on her own for months and years. So she was darn spoiled in Rexburg. And even Boise, I think she had some good treatment. So she was not as excited about the Maricopa County Jail. So she's anxious to be shipped back to serve her her sentence, her prison sentence in Idaho. But on the other hand, at one point she filed a motion for a new trial. So, yeah, but that was denied. And as soon as she is sentenced, she's going to be on the bus back to Idaho. So there are a few other updates. Madeline Soto, her trial is coming up. So there are two trials. Stephen Stearns is the defendant in that case. It's a case out of Florida. It's a really heinous case. It's awful. It's a case where he's accused of SA, of grooming and abusing this child since she was about 8. She was 13 when he allegedly murdered her. So it's a rough case. He is currently scheduled on the 7th or on the 22nd of July to start the first trial, which is the SA trial. The reason that Florida is doing them in that order is that if he is convicted of the child images, the child SA images that he's accused of, then he's facing 60 counts of that. If he is convicted of that, it is an aggravating factor in the murder and can go toward the death penalty. So it didn't surprise me at all. He has filed motions. There is a motion out there, and if anybody knows, I actually texted Joel to see whether or not he knew, because he's in Florida and been covering this. But I also texted to see whether he knew. His attorneys had filed a motion to suppress, saying that he didn't give consent to the police to go through his phone. And consent is a big issue that's going on right now in the Brian Walsh case. And I do want to talk about that a little bit too. So that's a case out of Massachusetts. And I'm going to talk about that a little bit more when we get to Reed and all of those. But he filed a motion to suppress because he said he didn't give complete consent for them to go through his phone. So I think the legal issues are a little bit more clear cut in his case, and I wouldn't be surprised if it's been denied, but I haven't heard. And when I started looking around online, I couldn't find where that had been ruled on yet. And I thought Joel might know, but I haven't heard back from him. But then he's on tonight too. So Joel from Surviving the Survivor. So right now he's on for trial for the 22nd of July, but of course that could change if there's other motions out there that need to be heard first. So the next thing I wanted to talk about was Tiffany Adams. Tiffany Adams is one of the toxic grandmas. This case is the Oklahoma, Kentucky. I always get it wrong. And I know that the chat will correct me, but she's one of the toxic grandparents. They met in this very remote location to exchange the children with their biological mother and a court supervisor. And when they met, they dispatch them. Oklahoma and Kansas. I knew Rachel would put it up for me because she's the one who keeps me up to date on it. And so it's a horrible case. They took the lives of these two lovely women. And it was all because this grandmother didn't want the mother to regain custody of the grandchildren. There were 5 people involved. 2 of them have rolled over on the other 3. Tiffany Adams, the case was on hold because one of the co-defendants, not Tiffany Adams, but one of the other co-defendants, had filed a motion to challenge the judge in the case, to recuse the judge in the case. The reason being that in 2011, the judge was still a practicing lawyer and represented Tiffany Adams, I believe, in a divorce, 2 divorces ago from her. And so when the judge denied it and said, I don't believe this is a conflict, which it isn't, then that person asked for an interlocutory appeal pretrial for a pretrial ruling. And it went up to the Supreme Court. Well, the Supreme Court has now, and so when you take an interlocutory appeal, that puts the case on hold until a decision's made. So the Supreme Court has now ruled that the judge is not disqualified, and that the 2011 representation of one of the co-defendants didn't disqualify him from hearing this case. So the case can now resume. There is a status conference on July 30th. Now, I'm going to have to look at this because it appears that they do things a little bit differently there, because they're on in November for an arraignment, which is surprising that these folks have not yet been arraigned. I know that a couple of them have already been to pretrial hearings. So there's already been preliminary hearings. And at those preliminary hearings, the 2 who rolled over testified. So I don't know why it's taking such a long time for them to actually be arraigned, but I don't know the rules of procedure there. So we'll have to see. The next thing I want to talk about is Brooks Houck. This is a case where there's no video. It's not being live streamed, but Lawyer Lee has been there in person, and she's been doing an awesome job of covering it. So if you don't follow Lawyer Lee, please do, because she's doing a great job. So this is a case where Brooks Houck is the primary defendant. He's got a couple of co-defendants, Joey and his, I think it's, I don't know, Smith, Stevens. It's in last week's notes, so I'll look it up. The co-defendants were accused of helping Joseph Lawson and Stephen Lawson. They were accused of having helped him, aided and abetted him in the case. Crystal Rogers is the victim. Her body has never been found. So that always makes a murder case more difficult, but not impossible. And so what's been really interesting about this, and why you probably ought to tune in to Lee's coverage of it, is because Brooks House's, thanks Tiff, Brooks Houck's family has been implicated, including his mother. His mother didn't like Crystal. He thought she was kind of trashy and wasn't good enough for her son. And there was a lot of bad feelings. And so Joey Lawson's father, Steve Lawson, went to trial in a separate trial and was found guilty of aiding and abetting in Crystal Rogers' murder. But Brooks Houck has not, and Joey Lawson are now on trial. Brooks Houck for the murder, and Joey Lawson for aiding and abetting. So there were some interesting things that came up. The prosecution rested and the defense started putting on their case. I don't think they finished today. They had 10 witnesses they were anticipating, so I don't think they finished. So they probably will finish their case tomorrow and it will go to the jury. there was a cadaver dog that alerted on Anna Whiteside's car. She is Brooke's grandmother. So Brooks Hauk's grandmother. And she had a white Buick, and the dog alerted on that car as having held human remains. So the defense put on an expert, a dog expert, how familiar does that sound, to talk about the dog's training and to sort of diss the dog and say the dog wasn't trained right. And to bring that into question. And then they put on 3 coon hunters who were out, and one of them said they saw Anna Whiteside's white Buick that night. Brooke's sister was put on more or less to sort of humanize him. She didn't have a lot of, one way or the other information, but Lee said she thought she was kind of on there to humanize him. So defense will continue tomorrow. It's likely going to go to the jury on maybe Friday, or they may just do the jury instructions conference and charging conference, and then do closing arguments on Monday. So a lot of times judges do that if they're close to the end of the week, just so the jury comes back fresh to do deliberations on Mondays. So that is maybe what's happening there. Corey Richens was charged with a whole slew of new charges, 14, 24, 26 new charges. 5 counts of mortgage fraud, 5 counts of forgery, 7 counts of passing bad checks, 1 count of communications fraud, 1 count of a pattern of illegal activity, and 7 counts of money laundering. So that gets tacked on to all the other counts, including the murder and the attempted murder, because she apparently attempted to murder him with a poisoned sandwich on Valentine's Day. Happy Valentine's Day, honey. And he got very sick, but of course recovered. And so then she was forced to get some more powerful fentanyl, allegedly, and spike his Moscow Mule with it. Undoubtedly, this will slow down her trial date. Putting out new charges, there's going to be more discovery, there's going to be more motions, and so without a doubt, this is going to probably push her trial out. So even though Karen Reed has been exonerated, I thought that there were a couple of interesting things that y'all might want to see. This is a video. Now, these creators, called the Young Jerks, Jurks, have been on the Karen Reed case from the very beginning, and been huge supporters of Karen Reed. And I think they are the only ones who have potentially scored an interview with Alan Jackson. I could be wrong, but this came up from them. If you remember, during the Reed trial, they tried very hard to get into, to bring in some photographs from 34 Fairview. If you remember, Judge Scortibello, or Dr. Scortibello, talked about the fact that the injury to John O'Keefe's head was from being hit or falling against something that had a ledge or a lip on it. And so they, the defense wanted to get in these photographs in this video of the house at 34 Fairview, and the judge didn't allow it. But the Young Jerks have it, the video, and I want to show it to you because I think it is really fascinating. And The young jerks have been incredibly generous with sharing these things. So this is Alan Jackson walking through the basement at 34 Fairview with his investigator and someone who's videoing it.
So basically every single part of the basement here, of this part of the house, the floor has been taken up. I mean, all of this is just hodgepodge, right? It just looks like it was thrown down. So the actual floor was ripped up. It's just a hodgepodge. All the way through here, yeah, the entire floor was ripped out. And then this goes into a storage area. This area did not have 4 minutes to begin with, but all of this.
So what's interesting about this is that we had heard that they had torn up the floor in the basement. I think I'm getting a message from Jen, so I want to make sure. Jen, are you texting me? Oh, you can't see or hear the video. It might help if I share my screen. My goodness. I am so sorry. It helps if you actually share your screen first. So let's try this again. Here we go. Let's make that full screen. And let's try it again. Can you hear it?
And once you get to the hall inside that room is some floor. Yep. Or is it? Let me look. No, there's no flooring. All right, so basically every single part of this part of the basement, of this part of the house, the flooring's been taken up. I mean, all of this is just hodgepodge, right? It just looks like it was thrown down. So the actual floor was ripped up, and this is just a hodgepodge of plywood. All the way through here, yeah, the entire floor was ripped out.
Now, what's interesting is this is a finished basement. You can see there's wainscoting on the wall, there's molding, this is a finished basement. And most people would use, thank you, Tiff, for letting me know. Most people would use this as a party space, right? Or would use it as a bonus space. So now remember that Brian Albert and Nicole Albert sold this house after John O'Keefe was found dead in the yard. So within a few months, they put this house on the market and sold it. This was Brian Albert's family home. He had lived in that home his whole life and actually bought it from his parents, raised his children there. So in very quick order, they sold this house, but not before they ripped out all the flooring in the basement.
And then this goes into a storage area. It looks like this area did not have flooring in it to begin with, but all this is looks to be relatively recent plywood.
Here's something.
Are you getting enough light to actually get this?
Yeah.
Okay.
Here's something else that you're going to see that's really interesting. Once again, I want to thank the young jerks. Please go and subscribe. They're awesome. And I had to laugh because they recently did an interview with a couple of people, including a retired FBI agent. And when I saw that, I was like, oh, please do not tell me that they have gone down the Jennifer Coffindaffer rat hole, because she is so bad and so unethical. And I have said it to her face, and I will continue to say it to her face. She is a disgrace to her title as a retired FBI agent. Well, they had a truly retired FBI agent on, and she made short work of Jennifer Coffindaffer, as well as having some really important things to say. So definitely subscribe. If you don't, they're great.
Okay.
So this is the next piece. This is the garage. Now, they were in the basement.
The point is, it's never been sampled.
I think this is the reason why the judge decided not to allow the pictures. There's a bunch of red paint spilled there, and it's kind of splashed. One could wonder if it was purposefully done to cover up something else. But it is definitely red paint, and it's kind of splattered, and it sort of runs down and drips. But when I saw that picture, a still picture of it, I thought, I wonder if this is the reason the judge said no. It was just might be too prejudicial. The jury might think, oh, there's a red splatter there, it's got to be blood. It's not, it's paint. But it does make you wonder about whether or not it's red paint covering up something. So it looks pretty gruesome.
Okay. No. Okay, will that door open? Paul, come take a look at this.
This is the part I really wanted you to see, though.
This is a bulkhead door. Look at that.
Yeah.
Directly into the backyard. Yeah. Okay. Get an establishing shot from over there. And I'll get out of the picture.
This guy's been using a while.
Now you're going to see this
Okay.
from the outside.
I don't think we need to go up and pull the bulkhead up. But
Okay. You gotta get rid of it. Okay.
Okay. One finger. I mean, there's nothing to open this. Wow. And look at that. There's the door.
Yeah.
Directly to the basement. This is. I'm gonna pace it off. Let's say we come up from here.
Okay.
This is the door that we opened earlier. Right here. And 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 paces. And look where it goes.
Right.
It's a straight shot. You open this door.
Yep.
What are you looking at?
Right to the flag.
I'm thinking about how deep was the snow. Thinking
It was a dusting.
Yeah.
It was a dusting. Yeah. I mean, it's, what, 6 inches? This door opens on 6 inches of snow.
They're pretty motivated. They're pretty strong. They're pretty smart.
And look at this. 1, 2, 3, 4, 5, 6. 24 paces.
Yeah.
Yep.
I like the theory.
And look at the cover.
Yeah.
Look at the cover. You see, you can't. The only time there's snow is the last 2 feet.
You know, like you said, everybody's even the pocket. Every season.
So what Alan Jackson is saying is look at all of the cover, the way that you would not be able to see what was going on. And the shrubbery there are rhododendrons, and they're evergreen. So even in the winter time, you would have had a lot of cover there. So I will stop that. But I once again, thank you to the young jerks. Sorry. I think that was really telling. And I'm sure that they wish they'd been able to get that in. As it turned out, they didn't need it. But it was fascinating to see. Definitely give you a little bit different perspective. So the last thing I want to talk about before we open it up to questions is the Brian Walsh case. So there are 2 other cases in the Boston suburban area that are still outstanding. There were 3 cases: Reed, Sandra Birchmore, and Brian Walsh. And all 3 cases have been on our radar because Michael Proctor was the lead investigator on all 3 of them. And Yuri Buchanan and Lieutenant Fanning were all involved, and they're all Massachusetts State Police. They were all involved in the investigations. So here's what's happened recently. We talked a little bit when we were talking about Stephen Stearns about consent to search a cell phone. So what happened in the Walsh case was Anna Walsh went missing. At that point, they did not know where she was. She was simply a missing person. Brian Walsh, her husband, didn't report her missing for several days. Now, he said that wasn't unusual because she had a business. She commuted between Massachusetts and Washington, D.C., where she had a business. She was in commercial real estate. And she also had a lover in D.C., but she actually had they had a second condo or something in DC where she would go, and she worked several days a week out of Washington, DC. They had young children, and their home was in Massachusetts. So she disappeared. Now, Brian Walsh said it wasn't all that unusual for her not to be in communication with him when she was in DC. Not sure that with young children, he was at home with young kids. Not sure that's so accurate, but maybe. So she was reported missing, and the police came to talk to Brian Walsh. They were mounting a search for this missing person because supposedly she got in a Uber or a Lyft and went to the airport, and that was the last anyone saw of her. Well, she never got on her flight that was scheduled to go to DC. And Uber and Lyft didn't have any record, neither Uber nor Lyft had any record of a driver picking her up at her home in Massachusetts. So suspicious. So what happened was Brian Walsh was under investigation for a federal investigation for selling counterfeit Andy Warhol paintings or prints or something. And so he had a criminal lawyer. So when they asked him, can we have your phone? We want to see the text messages between you and your wife from Christmas until she went missing. So a week. She went missing on New Year's Day. So he said, well, before I do that, I'm going to contact my lawyer. So he contacted his lawyer. His lawyer got in touch with the prosecutor and the investigator in the Anna's disappearance. And she said, my client will allow you to see all of his text messages for that fixed period of time. So you may only get text messages between my client and his wife between this date and this date. That's all you can have. Well, we know about Cellbrite, and we know that Cellbrite is an all or nothing proposition. You either download everything or you download nothing. The other thing she said was, we do not agree for you to look at any of his communication between his lawyer and he. That is all covered by attorney-client privilege. So stay out of that. You can have this finite amount of stuff. The district attorney and the lawyer exchanged emails memorializing all this in writing, that this was the only thing they were going to take. It was all in writing, and that was all that they were going to agree to. So then Yuri Buchanan sends Officer Fanning over to get the phone. He picks up the phone and the son's iPad. And there was a reason why they picked up the son's iPad. The 6-year-old son said, Mommy was here in the morning and I had a problem with my iPad, and she fixed it before she left with her suitcase. Now, we don't know what day that was. This child is 6. Children do not have a great understanding of time. Kids don't really develop a spatial understanding of time until they're like middle school age, like late elementary, early middle school stage, where they really begin to understand. If I say something is due on Wednesday, today's Monday, tomorrow's Tuesday, they just don't they haven't gotten that temporal concept yet. So whether or not this child, 6 years old, saw his mommy on that morning, whether that happened that morning or whether it happened on a different morning, I don't know that anyone understands. But the police said, we would like to see that iPad to see if there was a problem with the on and off switch or something, and she had to do a restart on it. If she did that, it'll show up in the log, and we'll have a better idea of when she was at home. That makes sense. So they wanted the iPad for that reason, and they wanted the phone. Apparently, the 6-year-old also had a phone, which is a little surprising, but a lot of kids play games on them, I guess. And so anyway, so they picked up the 6-year-old's mini tablet and phone and Brian Walsh's phone. And they did a Cellbrite extraction on all of them and returned it all to Brian Walsh the next day. But they had all that information. So even though they had a specific and very strict agreement on what they were allowed to access, they looked at all of it, including his GPS locations and his Google searches. And his Google searches came up with things like, how long does it take a body to decompose? How do you dispose of a 120-pound woman? How long before a body starts to smell, and a lot of other really graphic and awful searches. And they also found that he had been out potentially distributing body parts to dumpsters. And they used all of that information to get search warrants and eventually to get an arrest warrant. It's all part of the probable cause affidavit. So his attorneys have filed a motion to suppress, saying you did not have a right to get anything except these text messages from this date to this date. Anything outside of that is a violation of his right and needs to be suppressed. If they suppress that, there is nothing. Now, they're going to argue we eventually would have found it, and, but they would have had to get a warrant. Well, did they have the basis for a warrant? It wasn't until they saw those searches that they used that as the justification to get the warrant and go out and start searching for. They found a bunch of implements in his house and some bloody rags and some other things that they otherwise would not have found. So we are squarely into the fruit of the poisonous tree. If the judge says this Cellbrite search was illegal, you had no right to take anything except that finite few text messages, then anything that they discovered as a result of that phone download is out. And at this point, that can mean that Brian Walsh is going to walk. This is yet another example of shoddy police work and the right hand not knowing what the left hand is doing, because Michael Proctor was in charge of that investigation. Yuri Buchanan was in charge of that was overseeing Michael Proctor. He was Michael Proctor's boss. And Michael Proctor should have known that they had an agreement on what could be accessed out of that phone and what could not. And that probable cause affidavit for his arrest should never have happened based on those phone records. So really interesting to see what's going to happen. I'm certain they're going to throw Michael Proctor under the bus again. I mean, he's the likely target. But let's remember that Yuri Buchanan was his boss. And Yuri Buchanan has already been called into question in the Reed case. If if Brian Walsh walks, it's going to be a problem. And I really think this is part of a bigger investigation. This is what makes me wonder, makes me disbelieve the fact that the FBI investigation is closed. And the FBI agent that was on the Young Jerks was talking about the fact that you can make a case inactive and reactivate it the same day. Just because a case is in an inactive status doesn't mean it stays inactive. So the very fact that the police chief in the Reed case in Canton said the FBI's closed their investigation doesn't mean anything. So I think that there is a much deeper investigation going on because we still have the Birchmore case. And it wasn't until the feds came in and investigated that Matthew Farwell was even looked at as and the case was even looked at as a potential murder. Before that, the medical examiner ruled that it was a suicide. And it wasn't until further investigation that the feds came in and said, no, something smells here. And Lieutenant Fanning was the police officer who missed 37,000 text messages between Sandra Birchmore and Matthew Farwell. So I think that that the Massachusetts State Police and the police departments in Canton and Stoughton and all those other little suburban towns outside of Boston are still firmly in the sights. Yeah. So I am ready to take questions for anybody who has questions. While Jen is doing that, I want to remind you that we are going to be on a summer schedule for the summer while I am working on my new project. So we're going to go to a twice a month schedule. We will be sure to put it in the show notes and also on the YouTube community tab so everybody knows what the dates are. But we will have a show on the 16th of July, the 6th of August, and the 20th of August. And then in September, we'll get back to a regular schedule again. So, so let's take your questions. I see there's a lot of them in there. I see a lot of stars in the chat. What you got for me, Jen? Oh, polio. I think you're talking about Kohberger. I think it's possible that he was medicated. We know that Lori Vallow was medicated during her trial. I think it's possible, but I think it's also possible. Remember, Ann Taylor made a fair amount of noise about the fact that he had been diagnosed with Asperger's. And I think that his affect was not all that surprising for someone who's been diagnosed with Asperger's. They tend to have kind of I don't mean to generalize because everybody who's on the spectrum is different, and I don't want to generalize, but I think that some people with Asperger's can come across with a fairly flat affect. And I had always felt that that was something that was a problem for him. He doesn't make a lot of eye contact. He's not overly emotional. He's, so it didn't surprise me that he might present that way in trial. I'm also sure that Ann Taylor did her best to prepare him for this. So he knew what to expect. He knew what the questions were that were going to be asked. He wasn't surprised by any of it. And I think she probably, they may have even done some role playing or some mock sort of things to sort of prepare him for that. So not surprising at all. Yeah. Could be he was medicated, but wouldn't surprise me if he wasn't either. Remember, Lori Vallow said during both of her trials that she was on no medication at that point. So, didn't help her one way or the other, did it? Hi, Flashback. Why would the prosecution not insist on a full allocution as a condition of the plea bargain? Okay, so and you want to talk about Mark Hoffman. in Utah in 1987. So I think there are a number of reasons why not. First of all, Mark Hoffman's case was in 1987, so we've got a few decades that of law changing. It also was in Utah, so a very different jurisdiction. Utah is a very different jurisdiction than most states, and so I think that out of an abundance of caution, the prosecution would not require that, because I think that there would be a basis to challenge his plea as coerced if he were coerced into making a statement that incriminated him beyond answering, yes, I did it, and guilty. So I understand that it is a big frustration for people who want to hear from his mouth why and what. But I was not at all surprised, and I don't believe that the prosecution was going to go there, because I don't believe that they would jeopardize the plea. And I think there could be an argument that beyond admitting, as the judge very methodically went through and said, did you enter the house for the purpose of committing murder? Yes. Did you, with malice and forethought, murder Maddie? Yes. Did you, with malice and forethought, murder Xana? Yes. Did you? And he went through each one of them, and to each one of them, Kohberger said yes. So clearly he admitted the conduct that that amounted to the charge and met the legal requirement for it. I do understand how frustrating it is for all of us and for the family not to have that final look you in the eye bit of closure. We may hear something from him at sentencing. He's not foreclosed from making some sort of a statement at sentencing, and we could hear that. But at this juncture, I think it was wise for the prosecution not to insist on that, because I think that there could have been a challenge to him being coerced into giving up his right to not to self-incriminate. So, and as I say, Utah is a very different state than Washington, or Washington. Sorry, Idaho. Took me a minute. He was living in Washington and in Idaho. So, hi, Nikki. Judge Hippler said after the sentencing, he will unseal the court documents. Are you going to request them? If this would have gone to trial, what's your opinion on him being found innocent or guilty? On what I know, I'll start with the second question. On what I know, I would say that the state had enough evidence to convince a jury that he was guilty. Now, it's all circumstantial evidence, but I think that they could have made the circumstantial chain get from point A to point B and had adequate to prove his guilt. I think a jury could easily have found beyond a reasonable doubt that he was guilty. And I think that if they did that, I think there was a very good chance that there was no mitigation that would have kept him from the death penalty being imposed. So, Judge Hippler has been very much more transparent than any other judge in Idaho, and the judge in the Vallow case, Judge Boyce in particular. And he has earlier in the case said, I am not going to keep a bunch of stuff sealed. He unsealed some of the things that had previously been sealed in the case, and was definitely following the rules when it came to what could be sealed and not sealed. One of the things that he did seal was the motion for third-party culprit, and he did that to protect the people, the names and the identities of the people who were being floated as third-party culprits. So I know that he is going to unseal much of it. There will be some things that will remain sealed, but I think much of it is going to be unsealed because there are no trial exhibits, because we didn't have a trial. Those things will not be available, which I'm happy about. One of the things that is always troubling to me is when people get a complete set of trial exhibits and they include autopsy photos. Those are very difficult, and I have some serious objections to them being distributed on the internet. It's just wrong and disrespectful and awful. And so I never, ever object. And I always, when I present a FOIA request, specifically say, I have no objection to having those images redacted. I'm not seeking them. I don't want them. I've seen too many in my career, and I really don't want them if I don't have to have them. I will tell you that when I do and have experienced those images, I always stop. I say a little prayer. I remember to honor them as human beings, as someone's child, as someone's mother or sister or father or brother. And I try to do that. I think that we can get to the point where we look at these things so clinically that we're looking at it from the pattern, the facts, what the scene can tell us, and we forget to remember that these are people. So I learned this from a lawyer mentor who said, never, ever treat this with anything but respect and reverence. And so I do. I say a prayer. I ask for their forgiveness. I recognize that I am not seeing them the way that they would want to be seen. And I always try and, remind myself that my motivation needs to be right. And that I need to not be doing this for any sort of exploitation. And I will tell you that my new project has given me the opportunity to go there recently. And it is sobering and important to remember that you're being trusted with something precious. So I absolutely support none of those being released. I absolutely support even the autopsy reports being sealed. And I think that the family should have the final say on whether the written reports are even shared. But I think that the system owes them and owes the victims to be treated respectfully. So that's the way I approach it and the way I will always approach it. This is why I said I can't judge Steve Gonzalez. I don't know what he's experiencing. I know I don't know, and I can't criticize him. I can simply ask you all to hold all of those families in your prayers and your thoughts, and send them good juju and good energy, because none of us are walking around in their shoes. And like I say, you know, as a parent, you think, oh, I could understand. And then, you know, as a person, you think, oh, I could understand. And then you become a parent and you think, I don't know how you ever got out of a fetal position. So I can't judge them. I can just ask you all to send them all your good vibes and feelings. And I hope and I pray that um, that after Kohberger's sentencing, that they will be able to begin to heal. It's a lifelong, lifetime challenge for all of them. But I hope that that will be a move in the right direction. And, you know, I hope that Brian Kohberger will give them some closure, either personally or publicly. I mean, I think that there is a good chance that he has every opportunity, even if he does not communicate publicly, he doesn't do an allocution. He still has the opportunity to help the families reach some closure. And he may. I don't know, because I don't know him. You know, none of us know him. But I do know that I think Ann Taylor is a class act. And I think that if she can facilitate that, she will. Because I think that at her heart, she is a decent, ethical human being. Everything I know about her, I read, everything I know about her makes me feel that way. And so I hope that, you know, sometimes lawyers have the opportunity to facilitate things behind the scenes. And there are many times lawyers do that and they don't want the credit and they don't get it and it's unacknowledged, but they do it because it's the right thing to do. And so if it's possible, I think she may continue to work in the background to try and get the families what they need. I know I would. So what other questions do you all have before we wrap up for the evening? Excuse me. Got teary and made my nose run. Sharon Hutchinson, can federal charges be filed against Kohberger since he crossed state lines? Interesting question. The federal law is, so the 14th Amendment here, we're going to get in the weeds a little bit. The 14th Amendment recognized that states have sovereignty and that the law belongs to the state. And it's only the areas of the law that the states cede to the federal government. Hopefully that makes sense. So the federal government's power to pass laws that typically are state rights, such as criminal codes, are fairly limited. So they're limited to things like the Mann Act, where you're actually transporting a person across state lines for criminal action, like Diddy. Or they are a crime that has somehow has a federal component, like RICO or like drug trafficking or trafficking where you're crossing state lines. Otherwise, I think that the federal government has to defer to the state. So in this case, where he went into the other state and committed the crimes there, the locus of the crime, the place where it was committed, is where the charges would come from. And he didn't cross a state line. He didn't break, it wasn't illegal for him to cross the state line. It is illegal to cross the state line and to force someone across the state line for criminal purposes. Okay, that's the Mann Act. So the act of taking a person from Washington to Idaho for the purpose of committing a crime is in itself a crime. And so that would be the reason why a federal crime could be charged like Diddy. In this case, it wasn't a crime for him to go from Washington to Idaho, but it was a crime for him to commit the acts he did in Idaho, but that's prosecuted under Idaho law. So there isn't a basis for a federal case the way there would be had he forced one of them across the border back into Washington. If he had kidnapped one of them and taken them to his apartment in Washington, that could have been a federal crime, but we won't see a federal prosecution. So, and jeopardy attaches at his guilty plea. So he would not be able, wouldn't be prosecutable, sorry, it's getting late, for any other crimes associated with those acts. So let's say that he also was driving intoxicated. Jeopardy would attach, and so that to that incident, he wouldn't be able to later be prosecuted for some related crime. So good question. What are your thoughts on the people from Twitter that are saying he was coerced to plead guilty? Well, I told you I do not play in the cesspool of Twitter because it is absolutely an awful place to be. I really dislike the fact that for a very long time, authors, it was really the place where authors congregated. And so a lot of authors were very active on Twitter. And I know that a lot of true crime creators, a lot of creators are still very active on Twitter. For me, it just got to be, it wasn't a political statement on my part. It just got to be that it was so toxic. And there were, in order to get anything good out of it, you really had to sort of wade through all the unpleasant, toxic stuff that was going on, the Jennifer Coffendaffers of the world. And so I just opted to not, I mean, I still have an account. I kept my account so somebody else couldn't take it over and pretend to be me, but it's, I don't use it. So I commented earlier on this. I do not believe that this was a coerced guilty plea in any way. We really went through that. I think Ann Taylor really just laid out the options and said, this doesn't look good. I think the state has enough to prove that you are guilty. And I don't believe that I have the kind of mitigation that would save your life. And I really want to save your life because that's what defense attorneys do. So, there is a person in the chat who just said she's lost 2 adult children to horrific things, and she would never want anyone to see her child in that condition, and the pain and the grief is forever. I just want to tell you that I love you, and I am so sorry, and you're in my thoughts because I cannot imagine the pain and the grief, and I am so sorry. So. Let's see if we've got any last questions before we wrap up. We're almost 15 minutes over the 2-hour mark, and I like to end up at the 2-hour mark, but I also love being here with you and sharing with you. So let's see. Last call for questions. Hi, Nikki. This outcome is positive for Ann Taylor. Is this outcome positive for Ann Taylor as an attorney? This is a good question. Ann Taylor is a very accomplished lawyer, and I understand that they have just tapped her to run the public defense services for the state, to be the chief, the head of public defense. And that's great because I think we need more really accomplished lawyers doing that kind of work. I know that she said that she was not going to, she had 2 death penalty cases that she wanted to continue on. This was one of them. And the other is a case, the name escapes me. Somebody in the chat may remember it, but it was a really tragic case. And the man is in, it has been declared incompetent, and he may never be competent to stand trial. It was a very unfortunate case where he picked up his young child he wasn't supposed to have visitation with and took the child and murdered his ex to get the child, and then the child died as well. And it was just a horrible case. Was probably mentally incompetent at the time that the crime was committed. He's most certainly continues to be mentally incompetent, and that is a case I don't know if it will ever come to trial, because I don't know that he will ever be competent to stand trial. But then, David Bryan Mitchell in the Utah, now I know it's been too late, kidnapping case. It took him 8 years, and he was finally found competent. So it's possible, but I think Ann Taylor will be retired by that time. So is it a positive outcome for her? I think that given what she was up against, I think it's the right outcome. I think that she put the best interests of her client first, and it was her desire to get him out of the death penalty. And so I think in that regard, I think she would consider it a win, because I don't think she was ever going. I don't think that she was ever going to be able to convince a jury that he was innocent. I don't think this was a Karen Reed scenario. And I don't think that she was ever going to be Elizabeth Smart. Thank you, Donna. I don't think she was ever going to be able to convince a jury that he was innocent, or raise enough reasonable doubt that a jury would find him not guilty. So, yeah, I think if I were in her shoes, I would consider this a win. Yeah. And I think ultimately she will say, I did the right thing. I did the right thing for my client, and I did the right thing. I was honest, and I was ethical, and I conducted myself in a way that was with integrity. So, and I think she has a tremendous amount of compassion for Brian Kohberger and his family. I want to point out that his family, just like a lot of other families, is pretty blameless in this. I know a lot of people have said Lori Vallow's family were somewhat to blame if they had been, hadn't been asleep at this switch. Maybe this could have been avoided. But I want you all to remember that the families of these perpetrators didn't commit the crimes. They're not guilty of anything. And I am certain that Brian Kohberger's family is devastated. I mean, you can look at your child and you can say, no question, this is a young person who has deficits, difficulties, challenges. But to look at at your own child and say, this person that's my flesh is capable of doing this incredibly senseless and heinous act. As a parent, can we really do that? Can we wrap our brains around the idea that this person that we have known since their inception could be capable of doing that? This child whose nose we wiped and whose boo-boos we kissed, can we really, in our heart of hearts, believe that? They have to be devastated. Every bit as devastated as Steve Gonsalves. And I understand that he believes that they're in some way complicit. And I don't know. I don't have the facts. I don't know. But it's hard. So while you're keeping victims in your prayers, keep them in your prayers too. Because in the end, we're all just walking each other home. And with that, I'm going to wish you good night. I'll see you in a couple weeks. Have a wonderful 4th of July. I hope you have many, many things to be grateful for and to celebrate. Don't forget that at the heart of it is the underpinning and the foundation of our country. And it is worthy of celebration. So I'm going to say good night, y'all. See ya.